Georgia's transfer upon death deed. We have an update. Let's talk about that. Back in July of 2024, Georgia passed a law creating the transfer upon death deed. And whereas their intentions were wonderful, because sometimes we all will maybe do something the first time and then have to go back and fix it. That's exactly what the legislature is trying to do. They were trying to produce this deed so that someone can name a beneficiary. And when they name the beneficiary, it completely bypasses probate. So they're trying to make it a little bit more simple so that you didn't have to use the joint tenancy with rights of survivorship deed, which also avoids probate. And you wouldn't have to put your children on title while you're still alive, which is it could be a big tax ramification down the line if you choose to do that. So they're trying to fix the problem with the transfer upon death deed. And the way they wrote the verbiage in it wasn't as clear-cut as it could be. And so there was a lot of closing attorneys that when this deed came up, when real estate was being sold, that they were putting the brakes on this, and the title companies were not wanting to write title policies on these deeds when these houses were being sold because of the language. The nature of the language in the bill was not clear. And I even talked to one of our closing attorneys about this, and he said a title company can write title insurance on it as it stands, but boy, you have to cross every T and you have to dot every I. You can't accidentally make a mistake in the process of executing one of these titles. So the legislature is going back to review this so they can fix the language. And as of June 2026, they are in the middle of fixing this. So if you live in the wonderful state of Georgia, I highly recommend you get with your representative and tell them to take a peek at this particular bill. It's House Bill 899, and tell them that if they have their language straight, to go ahead and amend this so that there's no more loopholes. But let's dive into those loopholes so you have a better understanding of why they're changing the language. The first loophole is the death certificate trap. Now, the way the current law is if there's a beneficiary named on this deed, then that person has 9 months to go in there with a death certificate and present it to the county to get that transferred into their name. Here's the catch though. Georgia's Vital Record Department doesn't hand out death certificates to just anyone. So if someone has named a beneficiary who isn't in the direct line of inheritance, maybe it is a long lost cousin and yet they still have kids, or I don't know, maybe it is a friend and that friend is not in the inheritance line, then Georgia Vital Records is like, I'm not handing that death certificate over to you. So that can get people hung up, and then they can't go execute the deed, and then it all has to go into probate, which was what they were trying to avoid. So they want to go out there and fix the health code that specifically says the transfer upon death deed, the beneficiary, whoever that is, has direct and tangible interest in the property, and therefore they can get a hold of that death certificate so they can go execute that deed appropriately and get it put in their name. Loophole number 2 is property maintenance, black hole. So when someone passes away and they have an administrator or an executor over the estate, normally that person has the right to maintain that property, whether it's the mortgage or pay the taxes, or they have the right to pay the utilities. But when you have a transfer upon death deed, that executor or administrator isn't supposed to touch that property because that property avoids probate entirely. And yet the beneficiary has 9 months to figure out how to get the paperwork in order for them to go out and get the deed in their name. So you've got a house that's kind of sitting in a black hole with maintenance issues, or maybe bills are not getting paid because nobody can truly take care of the property legally. So they are trying to fix up the loophole there to where the administrator or the executor can maintain the property until the beneficiary has appropriate time to go get that property transferred into their name. The administrator and the executor can also put a lien on the house so that that beneficiary can pay back taxes or maintenance issues that they would have otherwise paid if they could just jump right in and start taking care of the home. Loophole number 3. This is the precedented security curation. Now, this is where the title companies have been freaking out because creditors can claim onto an estate, or maybe a spouse can claim year support. They do not want to do any title insurance against this transfer upon death deed in fear of that these kind of issues could bring back that transfer upon death deed back into the probate fold, and somebody could, have credit card debt and say, hey, the equity out of that house should pay for it. Or if it's a spouse trying to claim your support, they could be like, well, I want your support out of this until I get my affairs in order. And then the beneficiary is not able to take on the house, sell it, and so title companies don't want to write title insurance up against it. So the solution to this is the bill is going to establish a pecking order that the transfer upon death deed takes precedence over general unsecured debt as well as year support. This should clear up any nerves that a title company might have by writing up a title insurance policy up against the sale of the house. So again, if you're in Georgia, reach out to your representative. Go out and watch this bill and see where it's at, and reach out to your representative to get them to pass it so it makes this transfer upon death deed better written so that it can be executed as it's intended to avoid probate. So the beneficiary gets the house that they were supposed to get, and they're not going to run into any of these stumbling blocks if they try to sell it later down the line. Also, if you're thinking a transfer upon death deed might be good for your own estate planning, I highly suggest you get with either a real estate attorney that specializes in real estate, or an attorney who is a estate planning attorney, so you really understand this law in detail and know if it is the right kind of title for you, because there's other ways to avoid probate other than going down this road of a transfer upon death deed. Now, is it an easy button and easy to change a deed like that? Absolutely. But there's other ways to make certain that your entire estate can avoid probate, and that requires a conversation with an attorney who specializes in estate planning. If you need one of those attorneys, let me know. I'll be glad to make the connection for you. And if you're going through probate right now and you're just a little bit overwhelmed and you're like, dang it, I wish we had the transfer upon death deed thing before we found ourselves in this situation, please feel free to download our 7 mistakes to avoid while going through probate, so that maybe you can avoid some probate issues and heartaches as you're going through the process. And of course, being real estate agents specializing in probate, we would love to help you out if there is a house involved and help you get that thing going and on the market and ready to sell. I will update you once this bill gets passed, and fingers crossed that it does, so it is written better and it can actually be an asset that we can utilize in this state to avoid probate and not have hangups with title insurance or even trying to get the deed transferred into someone's name. If you found this information helpful, you might stick around to the channel and watch the next video that comes up, and I will see you all later. Bye.